So what happens if you need to file bankruptcy, but you also have a pending personal injury lawsuit? What do? How's it treated? Watch my next video, find out. So a pending lawsuit is an issue that comes up in Chapter 7 and Chapter 13 cases. And I'm going to go over today how they're treated in each. So let's start with Chapter 13. In Chapter 13, it is a debt consolidation repayment plan under the protection of the federal courts. And so the way it works is you file your case, and for the next 3 to 5 years, however long your plan is set up for the next 3 to 5 years, your estate is going to be, what you're earning. That's why we have to put in your income from all sources, so we can figure out how much of this estate is going to be available to pay your creditors. And that's how we file a plan and whatnot. So a lot of times when folks file, they may have a pending case. So that, it could be, usually it's a personal injury case, and they don't know how much they're going to get because it's pending. So it's easy. We have to make sure that it's disclosed, and I cannot impress upon you how important it is that you disclose it. Do not hide this from your attorney, because it's going to come back and bite you in the butt big time. Because when you go to try to settle this claim that you did not disclose to the court, first thing opposing counsel is going to do before they settle it, you're going to sign a statement that you've not filed for bankruptcy. And you can't sign that under penalty of perjury, because that's not true. And so when then you do have to disclose under penalty of perjury, which you're signing your bankruptcy schedules under penalty of perjury too. But anyway, that's another story. As soon as they find out you filed bankruptcy, and some of them may check Pacer anyway to see if you filed, just to do a gotcha. But as soon as they find out that you have filed bankruptcy, first thing they're going to do is pull your bankruptcy petition. They're going to take a look and say, oh, you didn't disclose this as a claim, so therefore we don't have to pay you. And that's true. So make sure, number one, you let your attorney know, your bankruptcy attorney know, that you have a pending lawsuit, pending claim, and it is disclosed. Because if you don't, you're not going to collect. Promise. So moving on. Disclose it to your attorney, and super easy. As bankruptcy attorneys, at least here in Georgia, what we do is we file, it's called an application to approve special counsel. We file it. Your attorney that you've got retained doesn't have to do anything other than, I got to have a copy of your retainer agreement. This is for your own protection as well. You need a copy of your retainer agreement, and your attorney just has to sign a verified statement that we provide them. So, it should probably take maybe 15 minutes of their time. They send it to us, we do everything else. So it gets approved, and then once your settlement comes through, so you settle the case, you win the lawsuit, yay, and there's an amount that will then be disclosed, how much you're supposed to receive. At that point, we can then look to see how much of that settlement, if you need it. So for instance, if you don't need it for anything other than paying your bills, then the bankruptcy court, at least here in Georgia, is going to say, okay, you received $50,000 from your settlement. We want you to take that money and pay it to your bankruptcy case, so you can pay off your creditors and get out of your case. Now, depending on what kind of plan you're in, that may be a good thing or a bad thing. You may be paying back people you didn't have to pay back before. Again, that's something that you'll get into detail with your attorney at that time. But there's ways that you can make requests to keep that money out of the bankruptcy estate at that time once you do a settlement. But just understand that you still have to disclose everything. So everything in bankruptcy is always about disclosure. So if you have a personal injury suit, list it. We're going to list it. When you get the money, then we will talk about how you want to use the money, how you need to use the money. Bankruptcy cases are long. Let me give you some examples. Sometimes I have clients that they're in a personal injury, matter. They end up settling, but they need to buy a car. or their hot water heater, their air conditioning went out. There's lots of reasons why you may need to use that money for other things other than paying to your bankruptcy case at that moment. So again, it's just something that you talk about with your attorney. That's why you retained us. That's our job. So that's a chapter 13 when we're dealing with personal injury lawsuits. Now, let's talk about chapter 7. Chapter 7 cases are typically pretty fast. You're probably in a chapter 7 case 4 months from start to finish. But same rules apply. You have to disclose pending claims and if you have a pending lawsuit. So we're going to have that disclosed. And it really depends on the chapter 7 trustee in terms of if they're going to keep your estate open, or if they're just going to be like, I don't think this is really going to be worth my time. I'm closing it, taking it off my books, moving on. So I can't tell you what a chapter 7 trustee, where their train of thought is going to be about your claim. There are some trustees that it could be a possible recovery of maybe $2,000 for the estate, and they're going to keep everything open. And then there's some that, I'm surprised that they don't keep it open, but it's just not worth their time. So that is something that is completely subjective in regards to who your trustee is. But here's how it works. We disclose your potential lawsuit. And when you have your hearing, your 341 meeting of creditors, I have a video about this. So if you want to check that out, tell you all about it, what it is, how it works. But at your hearing, trustees are always going to ask you, do you have any pending claims against someone? And that's where you say, yes, I do. And they'll have already looked at your paperwork, but they also want to get you under oath again, saying, hey, do you have anything? Just in case you forgot to list it on those other documents that you signed under penalty of perjury. Let's make sure, you're 100%. So you'll state, yes, I do. I have a pending claim. So the trustee will ask you, a lot of times they'll say, well, has a lawsuit been filed? They'll ask you, how badly were you injured? And yes, it can seem a little intrusive, but they're allowed to ask that because they're trying to assess really if it makes any sense for them to care about your lawsuit. If it's just, you got a whiplash and maybe you're going to get back like $5,000 or $10,000. We have an exemption. We can cover at least $10,000 easily with one of our Georgia code exemptions, 44, 13, 100. But anyway, that's what they're doing. They're trying to assess, is it worth it? Do they care? Now, let's say the trustee says, you know what, I'm just going to keep this open, see if you end up getting anything that you can't protect. And those are exemptions. And again, got a video on this and how they work, all that good stuff. But if there's a possible, chance that, hey, maybe you're going to get $1 million from a lawsuit. I mean, it's happened. You're going to get all this money. Then the trustee is going to leave your case open so that when you do get that settlement, the trustee is going to send a notice to your creditors in your case to say, hey, there's a possibility that there could be some assets that come into this case that I could pay you. And so your creditors then will file claims to say, this is what Jane owes, blah, 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 blah. And then when the settlement comes in, the trustee is going to say, okay, I'm going to pay these people. The trustee takes their fee, which they're entitled to because they're doing legal work. And then you would get the rest. But I think a common misconception is people freak out and they're like, oh my God, I'm going to be in bankruptcy. Who knows when it's going to settle and blah, blah, blah. No. All it means is that the trustee is going to keep your estate open, meaning you're still going to get your discharge. So you still get discharged of your debt, your credit starts rebuilding, everything is great in that respect. It just means though that you've got this claim that's open so that if it settles, comes to something, then the trustee may want to get some of that money to pay your creditors. So that's how it works. So don't panic if you're in a Chapter 7 case. As I tell my clients, don't freak out if the trustee says, or they issue a discharge and you'll see it'll say discharge only, which means debts are gone, credit's going to start rebuilding, but they're going to keep the case open to see if your lawsuit pans out. And that's simply it. And so if you do have a pending lawsuit, but you need to file bankruptcy, it's okay. You can do that. And a lot of folks are like, hey, I wish I could if I could settle this, I could pay my bills. that's of course understandable. So if you get a sizable settlement in a 7, then yeah, maybe that's what's going to happen. They'll use that to pay some of your creditors. You know, most of the time, most folks' lawsuits are not huge amounts. And at the end of the day, even if the trustee keeps it open, eventually they just close it and they're like, yeah, not worth my time. But just know that that's the process so that you don't panic if you're in a Chapter 7 bankruptcy case and you have a pending lawsuit. Just know, make sure it's disclosed to your attorney so that it's properly reflected on your bankruptcy paperwork. And remember, you are signing these documents under penalty of perjury. So take the time to review your documents to make sure that they are properly reflected. I don't know how many times I've been sitting in a court hearing, listening to other cases, and the trustee will make a comment that, hey, this lawsuit wasn't disclosed. And the client is saying, well, I told my attorney. And maybe you did. Maybe you told your attorney. Maybe your attorney was busy. Maybe you didn't write it on your intake, but you told your attorney. All those things would be true. But at the end of the day, your documents that get filed with the bankruptcy court, you have to review those. You have to sign them. So if it didn't get disclosed, you should have not signed them because they weren't correct. So just keep that in mind when you're reviewing documents. I mean, these are documents getting filed in federal court. And I know sometimes people, they're in a hurry and it's like, oh, it's all blurring together. This is very important. You can't do that. You literally need to go page by page and check to make sure you've got everything disclosed. But if you have any questions about filing bankruptcy, lawsuits, and all that good stuff with bankruptcy, please, at least here in Georgia, do not hesitate to reach out. My information is below, and I'm always happy to answer questions.